from sunny North London and welcome to this webinar. I'm Ranjit Bhose and my co-presenter is Kuljit Bhogal. And we've arranged this morning's webinar to deal with the terms of Mr. Justice Nicklin's judgment last month in Barking Dagenham and Persons Unknown concerning persons unknown injunctions, a racy read at about 200 pages. And what we're aiming to do is to explain to you what it means, what its consequences are, and what alternative means there are available for dealing with those whose identities are unknown. The webinar will last for about 1 hour, and we'll try and answer some questions at the end, so please type them in if you can. If we are unable to answer any questions today, then both Kuljit and I are always available at reasonable rates and more than delighted to accept your instructions. Now, this being a webinar, I don't need to give you any advice about fire exits, and quite frankly, I don't care if you leave your phones on, so that's all good. Right, let's kick off. It would help if I could actually move the slides. There we are. That's us, beautiful photographs. And then we go on to what we're going to cover. I'm going to deal in general terms with persons unknown injunctions, how the law has developed in the last couple of years, particular problem areas, and then Mr. Justice Nicklin's judgment and what it means. And then Kuljit is going to deal with alternative options where the identity of individuals is unknown, and her particular focus will be on PSPOs and on traveller cases. So what has happened in the last few years, as I'm sure you're aware, is that local authorities have brought proceedings for injunctive relief against persons unknown against a range of threatened unlawful conduct, whether that be trespass to land, demonstrations, trees, unauthorised music events, borough-wide injunctions, principally aimed against the Gypsy and Traveller community, aimed at preventing trespass, breach of planning, or a nuisance in the way of deposit of waste, and other public nuisances such as car cruising or raves. And that method of seeking injunctive relief has become particularly popular in the last 20 years and has been seen by a number of local authorities as a real deterrent, an injunction having a preemptive effect, preventing people from so acting. And it's always been thought by authorities to be a sleeker and swifter means of enforcement than PSPOs or use of the powers under the Criminal Justice and Public Order Act 1994. And the old approach until the last 2 or 3 years has simply been to describe the defendants as persons unknown, to obtain orders to alternative service by placing the claim form, injunctive relief and the like on stakes on the land and also on the website. It's been a feature that injunctive relief has generally been granted on a without notice basis, and that when one comes to a hearing, there is almost always no attendance by any potential defendant, and certainly no legal representation. Orders for alternative service of the final injunction have been made. Again, they've been erected on the land, and generally the assumption has been by everyone that once made, the injunction bound everyone so as to regulate their future conduct. And this hasn't really been challenged for a long time. However, in the last 3 or 4 years, the higher courts have had a far greater focus on cases where proceedings are brought against persons unknown. And they've looked at it in different contexts, but they have analysed in real detail the practical and legal difficulties that can arise, and these cannot be understated. And I've set out on this slide 6 of the recent decisions within this area. You'll note Ineos, Quadrilla Bowland, and Canada Goose. They were all cases brought by private concerns seeking to restrain persons unknown from interfering with their own commercial interests, whereas Cameron and Liverpool Victoria had nothing to do with injunctions and was about suing an unknown hit and run driver. Also in there is Bromley and persons unknown. Those of you who work in this area will know that's the case where the Court of Appeal considered local authorities' practice of seeking borough-wide injunctive relief is principally aimed at the Gypsy and Traveller community, generally deprecated that approach and gave some valuable wider guidance. And also in there is Canada Goose Retail, which we'll look at, and then finally Mr. Justice Nicklin's judgment last month. Now, there are three particular general issues that we should get straight in the beginning. The first is what's known as the description requirement, because what the courts have recently held is that it is permissible to describe persons unknown defendants by reference to future unlawful acts which a claimant believes that persons may in fact commit. And it's been held in the case of INEOS, there is no conceptual impossibility in suing persons by reference to future unlawful conduct. But what has been confirmed by the courts is that if you're going to seek to sue defendants against that sort of conduct, then they must be described in the claim form by reference to the conduct which is alleged to be unlawful. For example, where you are concerned about people who may trespass in the future, it would be persons unknown entering or remaining without the consent of the claimant on land and buildings, etc. Or if you are concerned about those who are engaging in abusive behaviour, it would be persons unknown engaging in abusive behaviour in land marked X. So what you can't simply do, and which a number of authorities have done in the past, is simply refer to the defendants in the claim form as persons unknown or persons unknown occupying land. And indeed, in the Canada Goose case of first instance, Mr. Justice Nicklin remarked that the way in which Canada Goose had described persons unknown meant that someone who was in Penzance jumping up and down in the street saying, "I hate Canada Goose," would in fact have been bound by the terms of the injunction and the proceedings, and that couldn't be right. And the other point to note is that when you're describing persons unknown by reference to future conduct, that must be unlawful conduct. You have to be very careful about excluding potentially lawful conduct. The second point is service of the claim form. And again, this is an issue which hasn't really been given much thought by a number of authorities when seeking to bring claims against persons unknown. Now, the courts, as we know, generally act in personam. And in Barton and Wright Hassel, Lord Sumption made the point, which is obviously correct, that an action is completely constituted when the claim is issued, but it's not until it is served that the defendant becomes subject to the court's jurisdiction. And issues of service in this area are critical. Now, Cameron, as I said, the facts are very different for any of our cases. There, the claimant sought to bring proceedings against an unknown driver who had damaged their car in a hit and run accident. And they wanted to do that, then to get a judgment and seek to enforce it against the MIB. But the Supreme Court held that was impermissible. It was a conceptual and practical impossibility to serve that driver with the proceedings because they were unknown. And one could not use the proceedings for alternative service under CPR 615 or indeed dispensation with service to fill the gap. And Lord Sumption at paragraph 17 made this general statement of principle that you'll see in a number of the persons unknown cases. It's a fundamental principle of justice that a person cannot be made subject to the jurisdiction of the court without having such notice of the proceedings as will enable him to be heard. And he went on to say that it's an essential requirement of any form of alternative service under Rule 615 that the mode of service must be such as can reasonably be expected to bring the proceedings to the attention of the defendant. And this is a point that Mr. Justice Nicklin has highlighted in a number of cases concerning persons unknown injunctions. And then so far as dispensation of service, I'm afraid that doesn't provide an easy answer, because what Lord Sumption said is that it's difficult to envisage the circumstance in which it would be right to dispense with service of the claim form under 616 if there's no reason to believe the defendant is aware of the proceedings. And ordinarily, the courts have dispensed with service of the claim form when the defendant knows of the proceedings, but is in effect evading service. So that's service of the claim form. And then the third point to bear in mind is, well, does a person unknown become a contra? Because if you're suing someone by reference to their future unlawful conduct, how does that happen? And this has been resolved in a case called Gamel and is known as the Gamel principle. In that case, an interim injunction was made against persons unknown in September 2004, prohibiting them bringing caravans onto identified land. An order was made for alternative service of the claim form and the injunction order on that land. That's critical. A few months later, Mrs. Gamble moved a caravan onto the land. The terms of the injunction were communicated to her, and from that point on, she was in breach of the injunction, having brought her caravan on land. And she also became party to the proceedings at that point by virtue of the order for alternative service of the claim form having been made. So it's both things. Firstly, alternative service of the claim form, and secondly, commission of the acts which the injunction seeks to prevent, which is now found in the description requirement. And so it's important to note from that a person unknown doesn't simply become party to proceedings because an order for alternative service of the claim form has been made. They must, in addition, have committed one or other of the acts which bring them within the definition of defendant in the action. And so it follows that even if, say, you hand a copy of the claim form to a person unknown who is about to trespass upon land, if they do not then trespass on that land, they do not thereby become a party. They have knowledge of the proceedings, but they haven't done anything to make them subject to the court's jurisdiction. They haven't met the description requirement. That brings us then to Canada Goose. Now, Canada Goose was an action brought by Canada Goose against a number of persons unknown who were protesting on Regent Street against their store. And they sought summary judgment against persons unknown for a range of alleged unlawful actions. And that came before Mr. Justice Nicklin in the High Court, and he rejected the application. Canada Goose then appealed to the Court of Appeal, and that was similarly dismissed. And Canada Goose, the Court of Appeal, made a number of statements of principle, which you need to set out. The first is that a final injunction cannot be granted in a protester case against persons unknown who are not parties at the date of the order. That is to say, newcomers who have not by that time committed the prohibited acts and so do not fall within the description of the persons unknown and who have not been served with the claim form. So that's critical. The action at trial is only between the claimant, any named defendant, or any person unknown who the claimant can identify, for example, by a photograph or a description, and who they can demonstrate has been served with the claim form by virtue of alternative service, and also critically has undertaken acts in breach of the description requirement. Only then do they become a party proceedings. Only then are they potentially capable of being bound by the final order. The person unknown who knows about the claim form, who knows about the injunction, but has not breached it, has not become a party, and is not bound by any final order. That's a pretty important statement of principle there from the Court of Appeal. It went on to say that there are some very limited circumstances where the court can grant what's called a contra mundum injunction, i.e. one against the whole world. But the circumstances in which those have been granted are vanishingly thin. Essentially, they are granted only where the court, in order to comply with its own obligations under Section 6 of the Human Rights Act 1998, has to make an injunction in order to protect the claimant's convention rights in circumstances where there is no other real remedy. So in a sense, it's forced to act. So it's a very, very narrow jurisdiction used in very few cases. And in Canada Goose, the Court of Appeal held that protester actions, such as Canada Goose's, didn't fall within that exceptional category where a contra mundum injunction could be granted. The usual principle applied, i.e. a final injunction only operates between the parties to the proceedings. And it held that's consistent with the fundamental principle in Cameron, Lord Sumption's paragraph 17, that a person can't be made subject to the jurisdiction of the court without having such notice of the proceedings as will enable him to be heard. Now, Canada Goose, of course, concerned a private litigant in a private cause of action against protesters. But what it immediately threw up is whether the statements of the Court of Appeal of principle, paragraphs 89 to 90, if you're asking, were of general application, or if they were limited to certain classes of case. And that's when the cohort claims hove into view. Because Mr. Justice Nicklin gathered together a large number of claims in, I think, both in the County Court and in the High Court, where local authorities had sought and obtained either interim injunctive relief or final injunctive relief, which were generally directed at members of the Gypsy and Traveller community, i.e. Bromley-style cases. And there were some 38 different sets of proceedings that he gathered together, both interim and final. In general terms, they all prohibited use and occupation of land. They were all against persons unknown with different descriptions, and some of them also prevented deposition of waste or fly tipping. And the claims relied upon causes of action of trespass, nuisance, Section 222 of the Local Government Act, Section 187B of the Town and Country Planning Act 1990, Section 130 of the Highways Act 1980, and Section 1 of the 2014 Act. So a raft of different claims. And the judge gathered them together and case managed them very actively, it has to be said. And as a result of his active case management, a number of the claims were withdrawn or dismissed, in many cases because there'd been a failure by the local authorities to comply with, well, in fact, to obtain orders for alternative service of the claim form under CPR 615. The result being that after 4 months, the action simply hadn't been served on anyone and were doomed to failure, and they therefore withdrew their claims and left only a handful of others who took it forward. And so there were remaining before the judge a number of cases where final injunctions had been granted and there had been orders under 615, and some interim injunctions as well where it hadn't come to full trial. And the judge determined a number of issues of principle, including this one, which is the critical one for our purposes: whether the court has jurisdiction and or whether it is correct in principle, generally or in any relevant category of the claim, to grant a claimant local authority final injunctive relief against persons unknown who are not, by the date of the hearing the application of the final injunction, a persons whom the law regards as being parties to the proceedings and or on a contra mundum basis. And clearly the focus here was on persons unknown who had not, by the time of the final injunction hearing, both been served ordinarily by means of alternative service and also had committed acts in breach of the description requirement and were identifiable, again, and therefore you could seek relief against them. What it was really concerned with was all of those potential newcomers who, after a final injunction, might then come to the land and might then breach the terms of the final injunction, were they bound on any basis. And in a comprehensive judgment, the judge comprehensively dismissed every argument that the various local authority councils put forward as to why Canada Goose should be distinguished and didn't apply in the claims brought by them. And he accepted that the court does have power to grant an injunction which binds non-parties to proceedings, and that power extends exceptionally to making of contra mundum injunction orders. But he went on to say that traveller injunctions were subject to the principle that a final injunction only binds the parties to the action at the date of the order. They are the trial defendants. Any other persons unknown, dubbed newcomers, are not parties to the litigation at that date and cannot be bound. And he held furthermore that a newcomer cannot become party to proceedings simply by breaching the terms of a final injunction. The injunction simply does not bind them at all. And he went on to hold finally that travel injunctions do not fall within that exceptional category where the court is competent to act by way of contra mundum injunctive relief. So the consequences of the cohort claims were stark. So far as those who held final injunctions, the nature of his order was that the injunction only bound those whom the claimant could identify, whether by photograph or name, and demonstrate they had become the defendant of the proceedings before the final injunction. The final injunction, whatever it may have said on its terms, did not bind anyone else. It did not bind newcomers. And then, so far as those authorities who had interim injunctive relief, the judge held that if they wanted to maintain their claims and move on to a final hearing, then they had to identify all those individuals who had by now met the description requirement, i.e. had been alternatively served and had undertaken acts which brought them within the categories of defendant. If they were to do that, the case would be case managed quickly and a final hearing would be held. But the trial would be against the claimant and only those individuals. It would not be against newcomers. And it's right also to note that in his judgment, the judge was very concerned about what he considered to be the abuse of the Court 37 procedures for seeking injunctions urgently, and also was concerned about some authorities who he considered had obtained injunctive relief and then hadn't done sufficient to bring it on to trial. The point he made, based upon Cameron, was that interim injunctions are ones purely to hold the ring, and the claimant has to get on for final injunction hearing. So those are the consequences of the cohort claims. But obviously, if left undisturbed on appeal, there are far wider consequences for any claim brought by a local authority seeking quia timid injunctive relief to restrain future unlawful conduct. And it does seem to me that Mr. Justice Nicklin's judgment spells the death knell of travel injunctions against persons unknown. In future, claims will have to be limited to persons unknown who can be identified by photograph, car, registration number, etc. And it will be impermissible to seek to protect against every possible future wrongdoer. You simply can't do it. But it goes further, because persons unknown injunctions against travellers are just one subset of those cases where local authorities seek injunctive relief generally. And it appears to me that the decision also spells the death knell of claims for injunctive relief to restrain threatened raves, other nuisances, breach of bylaws, mass trespass to land. The only kinds of exceptions one might get is that if you're able to identify the potential organisers of the event, and you might have some sort of social media means of contacting them, you might be able to satisfy alternative service, and you might be able to get some form of interim injunction against them, but that's about it. The only potential chink, I think, in terms of any future relief might be in car cruising injunctions, because if the evidence demonstrates that car cruising, if allowed to continue without limitation, if that risks real personal injury or indeed threat to life of anyone attending or getting in the way or the like, it is possible that an authority could make out a claim that the grant of interim injunctive relief or indeed final injunctive relief is necessary to protect Article 2 ECHR rights, the right to life. But I have to say, I think that's going to be a very, very, very narrow window of opportunity. Added to all of that, the judge's approach to alternative service under 615 and what he said about abuse of Court 37 procedures, and also about not allowing interim injunctions to go to sleep, that means that in future it will be exceptionally difficult for a local authority to seek injunctive relief, whether interim or final, against persons unknown in any of these circumstances to restrain against any of this threatened unlawful conduct. And this, the likely future judicial approach is well illustrated by a more recent judgment of the judge himself in City of London Corporation and Persons Unknown. In those proceedings, the City of London Corporation, who are the owners of Epping Forest, sought interim injunctive relief against a number of categories of persons unknown, delineated by reference to their future unlawful conduct, seeking to ensure a law-abiding nature in Epping Forest and relying upon evidence of wrongdoing from persons unknown generally in the preceding few years. Now, the authority there had done all that it could to provide for, well, it sought to serve the claim form by alternative means, of course, and it sought to do that by placing the claim form on posts on the various parcels of land within Epping Forest and also in reference on its website. But the judge held that that service would not bring the proceedings to the attention of more than a fraction of the potential persons unknown. He noted that there were some 11 million visitors to Epping Forest per year, but service in these means could only bring the proceedings to the attention of anyone who happened to go to Epping Forest in the period between the grant of the order and trial. And he said that was simply not good enough and didn't comply with Cameron. And having done that, and having therefore refused to grant an order for alternative service under 615, in effect, the proceedings didn't get off the ground because the judge said, well, as I'm not satisfied that you can grant alternative service, the claim form, I cannot grant an interim injunction. There is no person over whom the claimant has established or is likely to establish jurisdiction. And he set out a number of general points which explains his view that this form of jurisdiction is simply improper. And what he said is it's not permissible to start a claim and obtain an injunction in the hope that a person may arrive at some point in the future and do something which qualifies him or her to become a defendant under the definition of persons unknown. He said it's one thing to establish the jurisdiction of the court over defendants by service of the claim form, i.e. the gamble principle, but it's something completely different to bring a claim where it's presently impossible to identify and serve any defendant. The court will be granting an interim injunction without having established jurisdiction over anyone. And what he said really, and this is the nub of it, that all of these problems stem from the claimant trying to fashion a remedy using the inter partes procedures of the court, not against identifiable defendants, but against the world at large. And this echoes a point made by the Court of Appeal in Canada Goose, that there are limits to the civil law. And both the court in Canada Goose and Miss Justice Nicklin consider that the limit is the proceedings are against the parties only, and you cannot seek to get injunctive relief to restrain threatened unlawful behaviour in the future against persons unknown, save for those who have become parties by the date of the final order. That will be a vanishingly small number of persons, and therefore, if left undisturbed by the Court of Appeal, and an appeal has been lodged, it does seem to me that the jurisdiction is as good as dead. So with all those of you who are local authorities, on that happy note, for those of you who are not, be happy, I move to Kuljit.
Just going to start the slideshow, give me a second. Thank you very much, Ranjit. As Ranjit said, the court has been very actively managing the persons unknown cases. Ranjit was in the Canada Goose litigation and in the more recent litigation involving the 36 authorities. And you may have seen that on our website, he and our pupil Verity have produced a short note on the judgments. If you are interested in finding out a bit more, but don't want to read all 200 odd pages of the judgment, it's worth having a look at the news section of our website to find their case note. It's worth a read and is much shorter than the 200 pages. The alternative, as Ranjit has said, is obviously send us instructions and we can help you with working out the difficulties in your particular area. But given what Ranjit has said about the rather depressing position we're left in with regards to persons unknown, I thought that in this part of the talk, I could look at some of the alternative options that might be available to you if you are facing situations where you've got defendants whose identities you don't know. And I know that particularly over lockdown, but more generally, there is a growing problem with things like unlicensed music events, raves, damage to open spaces. And the trend seems to be for these events to be more and more organised. They're organised sometimes at very short notice on social media, but they look like they're ticketed events. People are wearing wristbands, there's food and drink for sale, there are huge speaker systems. There's some organisation involved. And so this is a problem, and particularly heading into the summer, it's likely to continue to be a problem. And so it is worth looking at whether there are alternatives for how one manages public spaces. And that's in that context that I thought I'd look in particular at public spaces protection orders, but also the other options that might be available to you. Before I look at the slides themselves, just to flag that we are going to be saving some time for questions at the end. If you do have a question, if you put it into the Q&A, we'll try and get to as many of those as we can at the end. And with that, just to look at what the alternatives are. Now, this isn't intended to be a comprehensive list of alternatives, but it's to flag that there are other options now that we know that persons unknown injunctions are pretty much dead, subject to anything that happens on appeal. There's very limited scope for persons unknown injunctions to be sought on an interim or final basis. So for gatherings of the type that I've talked about, whether it's a rave or an unlicensed music event, or even if it's a car cruising, a car meetup type event, there are other powers available, and I've listed some of these on this slide. And the first set of bullets relate to powers that attach to the space itself and that apply to everybody within that space. So they're not individual specific. And it's worth noting that closure orders in particular are available not just for bricks and mortar accommodation, but they are also available in respect of open space. But the issue that you'll have there is in relation to how one closes that open space, if you're able to satisfy the court that you meet the test for a closure order being made. But I have conducted cases where we've sought a closure order of open space, or even things such as shopping centres, where we sought partial closure orders for part of the time because of the problems that were carrying on when the shops weren't open, but the centre itself was still open for people to as a route of access. So it's worth bearing those powers in mind in relation to space, and I'm going to come on to look at public spaces protection orders in a bit more detail. But it's also worth thinking about the practical steps that you can take, because sometimes with these situations, some of the individuals are known. What I've said there is that it's sometimes worth taking the approach that you'll target the ringleaders. And I've done this in a few cases, and it is effective if you manage to target the right ringleaders. So it depends on the intelligence that your officers are able to give you. But to give you an example, I used it for a case where people were using the quad bikes in an open area which was surrounded by residential properties. And there were 4 or 5 particular individuals who seemed to be there all of the time and acted as a magnet for the others. And we sought orders in respect of those 4 or 5 known individuals. So we were able to establish who they were and issue proceedings in the normal way for a remedy that attached to them as an individual. And so that's worth thinking about. It's also worth thinking about whether it's a situation that warrants the use of a community protection warning or a community protection notice. Now, those steps on the bottom half of the slide are dependent on you knowing who the individuals concerned are. But part of this is to take a slightly different tack rather than trying to attach and make an order that attaches to everyone whose identities you don't know, is to target the people that you do know. So the organizer of an event and so on. But part of the point is to then gather intelligence to think about whether in the longer term there are other measures you should be taking. So if there's a particular location or a particular behaviour which you're having to deal with on a repeated basis, that might then warrant you looking at remedies that attach to the space and make it easier to then justify having a remedy that attaches to the space, such as the closure order or a public spaces protection order. And it will become relevant why you need to look at those other options when we look at some of the detail in relation to public spaces protection orders. So worth thinking about those others. I'm going to look particularly at PSPOs, and you'll see here that I've referenced in relation to traveller cases the particular problems that exist. So what I say shouldn't be taken as a carte blanche to make a PSPO if you are an authority with traveller issues. And part of the reason it's not a blanket approach is because of the specific considerations that apply to travellers, and these were highlighted by Mr. Justice Nicklin in the recent judgment that Ranjit's been talking about at paragraph 15 onwards. And I've listed them on the slide. A lot of them stem from the fact that travellers, Gypsies and Travellers, are a protected group, and there is a particular vulnerability because of their lifestyle and the fact that their lifestyle, there aren't a sufficient number of places for them to park their caravans and for them to continue their lifestyle, and that the measures that interfere with their ability to station their caravans and vehicles has a potential to interfere with the article right to respect for their home, but also the ability to maintain their identity as a Gypsy and Traveller, a member of the Gypsy and Traveller community because of the transient nature of their lifestyle. And so the courts have said on numerous occasions and referenced in the most recent judgment that travellers require a specific and careful consideration. So please don't think that the answer is, well, we can't get an injunction, let's make a PSPO. That might be the answer, but one needs to take things carefully. I've listed the considerations there. I don't propose to read them all, but they stem from the fact that this is a vulnerable group that one's dealing with. And it's in that context that I thought it might be worth just highlighting, firstly, the possible uses for PSPO, but also to highlight that the other group that the guidance has identified as being a no-go area are rough sleepers. And when the guidance was amended last, that the PSPO section, the main focus was twofold. One was to deal with governance issues, but the other was to say that PSPOs shouldn't target rough sleeping for the sake of rough sleeping. So you may well have councillors in your area who say, well, you know, I don't like those people bedding up for the night in our shopping centre or outside the train station. The fact that you don't like something isn't necessarily going to meet the test for making a public spaces protection order. And in particular, there is a clear reference in the guidance to not targeting rough sleepers. And that really ties in with the traveller community, because although travellers aren't referred to in express terms in the way that rough sleepers are, they are another vulnerable group. And one does need to be mindful of the fact that there are particular considerations when it comes to vulnerable groups. The other thing to know about PSPOs is that for a number of years, Liberty and groups like the Manifesto Club have been responding to PSPO consultations. And Liberty, there's one particular case they did get involved in, which involved rough sleeping, which it didn't end up being litigated, it was compromised. But I think there are groups out there that are looking for the right case in which they can intervene or present somebody as a front man or front woman to bring a challenge to a public spaces protection order where they think it's too draconian or interfering with in a way that it shouldn't. So just to be aware that there are groups out there who are actively looking at what local authorities are doing in respect of their public spaces and particularly in relation to vulnerable groups. So possible uses for public spaces protection orders. On this slide, I've put some examples of the way in which I've seen public spaces protection orders used. And again, this isn't intended to be a suggestion that all of you should go away and look at introducing a public spaces protection order for these purposes, but to give you an idea of some of the types of situations in which they've been made. And we'll go on to look at how the statutory framework has been interpreted. In terms of that statutory framework, it might be a bit of a refresher for some of you who've attended a seminar that I've spoken at or know about PSPOs already. So, but I will just cover some of the basics. In terms of the overview, you'll find the powers to be able to make a public spaces protection order in the Antisocial Behaviour, Crime and Policing Act of 2014. and the relevant sections are sections 59 to 75. They allow you to control the use of public space. And the way I often describe them is that they attach to the public space and everybody within them. Unlike an injunction that is specific to a particular individual, or a community protection notice that is specific to a particular individual, in public spaces orders attach to the space. And so they affect the behaviour of everybody within that space. And that's partly why there are certain safeguards within the statutory framework to make sure that the powers are used in an appropriate way. They can last for a maximum of 3 years. And so at the 3-year point, you'll need to consider whether you want to renew your public spaces protection order, and at any point during the 3 years, you can consider whether it needs to be varied, or indeed, if you want to bring it to an end, you're able to bring it to an end. But it's a process that needs to take place every 3 years. It's fair to say that the bulk of the work happens the first time you introduce the public spaces protection order. And I've now dealt with a few cases where we've extended the public spaces protection order that we brought in 3 years previously. And the workload involved was much less, although there is still a requirement, both when you make a public spaces protection order, when you vary it or extend it to go to public consultation, the process is less onerous when it comes to extending as it is when you come to first introduce it. But they are evidence-based orders, and what I mean by that is that you have to be satisfied that the statutory tests are met in your local area. And so the situation in terms of the behaviour will vary from area to area, and your decision as to whether or not the test is met is also likely to vary from area to area. And then indeed what Mr. Justice Turner said in the High Court decision involving the Ealing abortion clinic was that these aren't meant to be orders that are made as a matter of course. And he was saying that about abortion clinics, and it's not a case where because you've got an abortion clinic, you can make a public spaces protection order. One needs to look at each case on its own, phrase that lawyers are familiar with hearing, but it is a very fact-specific situation and consideration, and you need to look at the extent to which the test is made out in your area, and not just it be a case of, well, the neighbouring authorities made one, we want one too. So that's just worth bearing in mind. I've put there proportionality. It features in a couple of ways in the statutory framework that we'll look at, but as you know, proportionality is about ensuring that you introduce measures that are appropriate to the behaviour concerned. And part of showing that they're appropriate is looking at what else you've tried, if you have tried other measures, but insofar as you haven't tried things, to show what else you've considered, but you've ruled out for whatever reason as being inappropriate. And that goes to the earlier powers on one of the earlier slides in terms of showing, well, we've tried a closure, say, but closures are for a maximum of 6 months, 3 months at a time, maximum of 6 months, or dispersals are for a maximum of 48 hours and we can't keep introducing dispersal powers every weekend. We think there's going to be a rave. And so we need a longer term solution. So using those powers, or at least considering use of those powers, can be relevant to then showing that it's proportionate to make a space-based order such as a PSPO. For those of you that had drinking in public spaces orders, gating orders or dog control orders, those orders continued for a period, then they transitioned to be treated as a public spaces protection order. But those transitioned orders expired in October of last year. So one of the things, takeaways from today, is to go and look at what you've got in your area. And if you haven't done anything about your old dog control order, say, it's a good opportunity to have a look at whether you want to do anything in terms of introducing new powers, because the dog control order is no longer going to be enforceable. So it's worth just having a review of what you've already got within your areas. If you aren't from a local authority, I thought it would be worth just highlighting why it's still relevant to know about public spaces protection orders. And indeed closure orders, which is the other power that is sits only with local authorities and with the police. And it's really about knowing what the tools are in the toolkit and then being able to ask your local authority to use them. if you think circumstances warrant them. And I know that with closure orders, a lot of housing associations work in partnership with their local authority or their local police force in order to secure closure applications. And a similar thing applies with public spaces protection orders. You're part of gathering the intelligence as to what's happening in your areas. You can ask them to utilise the powers if you think it's appropriate. But you also might find yourself being consulted about the powers, particularly where one of your estates or your properties are within areas that might be affected by a public spaces order being made. And so it's worth responding to those consultations when you're invited to, when you know that they exist, and making your views known about whether or not the proposals are appropriate. So that's why it's relevant to you to know about them, even though you might not be for the local authority. I've mentioned what the old orders were, just to flag that these what they were. But the reason for mentioning them is firstly to highlight that, check whether you had any of these and whether you've made new PSPOs in respect of this behaviour if it's warranted. But secondly, to highlight that although these were the old orders, PSPOs aren't limited to these types of behaviour. And I'm going to talk about a couple of the cases that demonstrate this quite well. And the first case that I'm going to look at did involve dog control, but then I will also look at the abortion clinic case and just tell you how that's relevant to the application of the statutory test. There is also a particular need to have regard to human rights considerations, not just because of Section 6 of the Human Rights Act of '98, but also because within the legislation for public spaces protection orders, authorities are required to have what's described as a particular regard to Articles 10 and 11. Those are the articles that protect freedom of expression and freedom of assembly. I've highlighted Article 8 there, respect for private and family life, just because that's another one that might be triggered. So you're not limited to having regard just to 10 and 11, but just that there needs to be a particular consideration of Articles 10 and 11. Other rights might also be affected. Article 9, freedom from religion, was a live issue in the Ealing abortion clinic case. Article 14, freedom from discrimination, might also be relevant. So it's worth knowing that human rights considerations play a part, and you'll need to demonstrate that you've had regard to these matters when considering whether a public spaces protection order should be made as part of your broader assessment of the equalities impacts and looking at your public sector equality duty. So what I've put there is that 10 and 11, and indeed Article 8, are all qualified rights. So there is scope to interfere with them as long as that interference is justified. And really that's just another way of ensuring that the order is proportionate and appropriate. And again, it goes back to looking at what else you could have done in terms of the options available, and whether there is a lesser restrictive measure that might have been more appropriate, and demonstrating that you've turned your mind to those issues. In terms of the test itself, to make a PSPO, there are two conditions that have to be satisfied. Firstly, you have to be satisfied that there are activities being carried on within a public space within your area that have had a detrimental effect on the quality of life of those in the locality, or that they're likely to have that effect. And that the effect or likely effect of the activities is that it's persistent or continuing. And that's the effect must be persistent or continuing, not the activities being persistent or continuing, although they might also be persistent or continuing. That the effect or likely effect of the activities is such as to make the activities unreasonable, and that the effect or likely effect justifies the restrictions being imposed. So it's there square in Section 59, the need to be able to justify the proposals that you're making. In addition to the main test that you have to be satisfied about, when it comes to the restrictions that you include within your public spaces protection order, Section 59(5) says that you're only entitled to include restrictions that are reasonable ones to impose. And they have to be reasonable in order to prevent the detrimental effect from continuing occurring or recurring, or to reduce the detrimental effect or reduce the risk of its continuance, occurrence or recurrence. And the point here is simply that any restrictions or requirements that you impose have to be connected to the behaviour that is said to be having the detrimental effect. And I've repeated the reference there to the human rights considerations. All of this applies when you make an order, when you vary an order, or you seek to discharge it. And as I've said, there is a process of requirement to consult at each of those stages as well. So the first case that considered public spaces protection orders that reached the courts was a case involving dog control. And it's called Summers and Richmond, London Borough Council. And essentially there were two main factual issues. There were a whole load of terms in relation to dog control, keeping dogs on leads by direction, keeping dogs out of certain areas. And then one of the other part of the order that was part of the main thrust of the challenge was that Richmond had introduced the maximum number of dogs that could be walked by one person. And it came out of a problem with professional dog walkers in the main, who were being paid to walk people's dogs when people were at work, or people who couldn't walk their own dogs because of a disability. And the evidence indicated that there were sometimes up to 12 dogs being walked by one person. And sometimes when they were all being collected on their round in the van prior to reaching Richmond to be walked, they'd been in the vehicle for a long time. They'd charge out of the vehicle onto the open spaces, and realistically it wasn't possible to keep that many dogs under control by one person. And then sometimes two dog walkers would walk together, and so you'd have even more dogs being supposedly under the supervision of those professional dog walkers. So that was the history behind it. And they introduced various rules about dog control, and then a maximum number of dogs that could be walked. And that was, as I say, part of what was being challenged by the claimant in that case, Miss Summers. The court considered a number of issues, but Mrs. Justice May made a number of observations that are helpful to PSPOs more generally, so not just limited to dog control. One of which was to say that to consider the meaning of locality. And what Mrs. Justice May said is that those in the locality, that being the statutory language, must be construed as meaning some, but not necessarily all of those in the locality, whether as visitors or workers. And this was in answer to the submission that was made that, well, some people like dogs and they like their dogs being walked, and so not everybody is being detrimentally affected. And what Mrs. Justice May said is that it doesn't have to be that everybody in a locality is affected, as long as some of them are. In relation to persistent, we found an old Ramblers Association case relating to highways provisions, which had also used similar language. And what Mrs. Justice May accepted was that essentially continuing or recurring or prolonged was another way of saying persistent or continuing. So it means more than once. And that was an argument that was accepted by the judge in relation to what the meaning of persistent was. And perhaps most importantly and significantly is that Mrs. Justice May at paragraph 25 said that really these are local decisions for local authorities to make based on their knowledge of local areas. And I've highlighted the paragraph, but within that she said that local authorities have been given a wide discretion to decide which behaviours are troublesome and require to be addressed in their area. And so really what it's suggesting is that there's a certain amount of deference that's going to be paid to a local authority's assessment of the problem. But that also means that there's a certain amount of trust and power that local authorities have. And so it's important to ensure that you do have the requisite evidence base and you do follow the right processes when it comes to adopting these orders, with a view to trying to make sure that you don't end up on the receiving end of a statutory challenge. So that was the first case, Summers in Richmond. The next case I want to talk about is this one involving the Ealing abortion clinic. And this was a case where, I'm not going to leave those pictures on the slide for very long for obvious reasons. Those pictures demonstrated what was going on. Essentially, there was a pro-life presence outside this clinic for the last 23 or 24 years. Often they'd be in groups of 2 or 3, sometimes the number would be larger, and they'd stand very close to the door of the clinic. So that picture with the lady peering around the brick wall, that brick wall is the front gate of the clinic, and the front door is about 2 to 3 meters behind that gate. So they were standing very close, wanting to speak to and engage with the people going into the clinic and leaving the clinic. Various things were said to those individuals, and various things were put on display, including some of the posters that you saw in that image. Some of them were quite graphic and in your face. They'd hand people leaving and entering the clinic models of baby fetuses, essentially saying, well, this is what you're carrying and that this is what you're about to murder. And sometimes they'd have models of fetuses or graphic images displayed along the pavement. And this particular location is a location that's quite close to a park and is also a through route to get to local schools and the local station. And so there was a lot of evidence from local residents about how they'd been affected, but we had evidence from individuals saying, well, their children were asking, well, what's this laying on the pavement, and being drawn into conversations they didn't want to have. So that was the background. So you can see already that the context is very different from dog control or drinking or a gating order. And this was one of the issues was, well, can PSPOs be used for behaviour that isn't traditionally part of what was before? And, you know, the consultation documents and things before the 2014 Act was brought in was all about protecting communities and in the context of those behaviours, or at least that was the argument that the other side ran. And the court, both at High Court level and then at Court of Appeal level, disagreed and said, well, really, the focus is to look at the statutory language and whether that statutory test is met. And it reinforced the concepts we've talked about, that detrimental effect is something that the local authority has a wide discretion to identify, and that they do it based on local knowledge and their assessment of what's going on in their own area. That those in the locality was an open expression, deliberately left undefined, but that it could apply to tourist areas. So we've heard about Epping Forest. The example that in the High Court that was given to Mr. Justice, in fact, I think Mr. Justice Turner suggested it, was, well, would Hampton Court be covered? And the answer is, well, yes. And so it's not just about, it can cover one-off instances, although as long as the behaviour itself is persistent or continuing. And so it's worth just bearing in mind that really the headline point is to consider the statutory language for making a PSPO and decide whether in your particular situation that statutory language is met. That's all I wanted to say, save to highlight one thing, which is that in the Nicklin judgment that Ranjit's talked about, one of the points that came out of it that we already knew but has really been reinforced is that although Mr. Justice Nicklin said that whether or not Section 1 ASB injunctions can be used for persons unknown is a point that requires further argument, the reality is it's very unlikely that we can use Section 1 injunctions for persons unknown situations. And as I've said there, it confirms what's been held in previous case law, and it's been reinforced yet again by Mr. Justice Nicklin in his recent judgment. So that's all I wanted to say by way of content. I know that there have been some questions coming in on the Q&A. I'm going to stop my screen share and just allow for those questions to be looked at.
I've been answering. I've been ignoring everything you've been saying, as I always do, and I've been answering some questions in the last hour. So all the rest are for you, my darling. You're muted. I've muted you.
I haven't had a chance to look at any of these. Ranjit, were there any that you saw that you think might be of general application that it's worth me looking at?
I think there's one question about, can you have a person's unknown injunction in the same area that you have a PSPO? And then another one is that if you have a PSPO that's due to expire in 3 weeks, and obviously you can't consult, is there any means of seeking to extend it or will it have to die its death and then you'll have to consult on a new one?
I'm going to answer that question first because that's a good one, and it reminds me of something else that I wanted to say. The difficulty is that the legislation doesn't make any provision for any form of interim order or any form of abbreviated procedure for introducing a PSPO. So if your PSPO is due to expire and you've only got 3 weeks left and you normally consult for a longer period, the reality is that your PSPO is probably going to lapse before you're able to then put a new PSPO in place. The work involved is very similar, whether you're extending or whether you're creating a new order in terms of the process. And if you've already got an order, even though you might be making a new order because you can't extend the old one, it's expired, the process is still the same. There's no way of bypassing the requirement to consult, and nor is there any way of putting in place a quick fix, which is why some of the other remedies are worth bearing in mind, even if your longer term option is looking at the PSPO. So that's that answer. And then in terms of persons unknown injunctions and PSPOs, it depends, because it depends on the behaviour you're targeting. So if you're targeting different behaviours, then potentially, yes, you can have an injunction dealing with matters the injunction deals with, and a public spaces protection order that deals with the matters that your PSPO is dealing with. But if you're dealing with the same matter, the same behaviour, then I think you have to be much more careful, because the question is, how are you able to justify a PSPO being proportionate if and justified if you've already got another mechanism for dealing with that behaviour? Now, it might be that other mechanism isn't working, or there are problems, or there are gaps in how it can be used, but you need to consider whether the test for making the PSPO is met and whether you're able to justify it in terms of the factual situation.
Okay, well, I think we have taken up 2 minutes more of your time than we should have done. And although there are a few of the questions that we haven't yet answered, I think we'll call it to a close. What we'll try and do is try and answer some of the questions we haven't got by email directly, or if it's something which is particularly concerning you, please do email either of us and we'll do our best to respond. Other than that, it remains for me to thank you all for attending and have a great day. Kuljit, anything from you?
I'm just going to suggest to George, if he leaves it open for a little while, it means people will be able to look at the Q&A, because if we close it, it closes access to the Q&A. So if we mute ourselves and turn our videos off, but leave the seminar running for a few minutes just to allow people to look at those questions.
Yeah, and I think also quite a few people asked if these slides would be available. They will be available in all good bookshops. Right, lovely. Well, I'm now going to go and take my tie and my shirt off and put my t-shirt back on. Have a good day. Bye-bye.